Hello everyone. It is often said once we pass through the toughest path, the rest of the path becomes easy. The same goes with 2024 prelims paper. 2023 ಅಲ್ಲಿ prelims paper ಜಾಸ್ತಿ difficult ಇತ್ತು. The polity section likewise was more difficult. But if we see in the year 2024, the difficulty level has decreased. So someone who has attempted 2023 questions, he would be prepared to even attempt more tougher questions. But that sort of tough questions was not been tested in the year 2024. So 23 ಬರ್ದೋರ್ಗೆ 24 paper easy ಅನ್ಸಿರುತ್ತೆ. So likewise today, like the rest of the videos where we have discussed PYQs beginning from 2020 to 2023, in this video we'll be discussing about 2024 prelims PYQ of the subject polity. Like I said, once we pass through the rough path, the rest of the path becomes easy. So we'll begin with the video. How many delimitation commissions have been constituted by the government of India till December 2023? Delimitation commission ಬಗ್ಗೆ we know that delimitation commission are established by the parliament under a delimitation act. ಆದರೆ ಇಲ್ಲಿ how many commissions have been constituted till now ಕೇಳಿದ್ದಾರೆ. This is not something which we would have studied or we would have come across when we are studying. So how is that we could have answered? Option 1, 2, 3, 4. ಇದನ್ನ ನಾವು ಓದಿಲ್ಲ, but things related to delimitation commission we have studied. What are those things which we need to recall? Delimitation commission is supposed to happen every 10 years. For every decade, delimitation commission is supposed to happen after every census, right? So delimitation commission ಬಗ್ಗೆ recall ಮಾಡ್ಕೊಳ್ಳೋದು ಹೇಗೆ ಅಂದ್ರೆ, see, we know that by 42nd amendment of 1976, by 42nd amendment of 1976, India, the government, it froze the seats allocated to parliament and the state legislative assemblies. Why did it do? To ensure population stabilization measures. So 1976 ಅಲ್ಲಿ froze ಮಾಡಿದ್ರು. And we have also studied in Lakshmikant that 2002 ಅಲ್ಲಿ, based on 2001 census, there was shuffling of the constituencies. The seats that were allocated to the state were kept the same. Only the redrawing of boundaries of constituencies were been done in the year 2001. Maybe it was through 86th or 87th amendment, something like that. So 1976 ಅಲ್ಲಿ seats froze ಮಾಡಿದಾರೆ ಅಂತ ಗೊತ್ತಾದ್ರೆ, what is that we can think of or take a smart guess of is 51 ಅಲ್ಲಿ ಆಗಿರುತ್ತೆ, 61 ಹತ್ತತ್ರ ಆಗಿರುತ್ತೆ, ಮತ್ತೆ 71 ಹತ್ರ ಆಗಿರುತ್ತೆ. So 3 times ಆಗಿರುತ್ತೆ. ಅದನ್ನ ಬಿಟ್ಟು 1976 froze ಮಾಡಿದ್ಮೇಲೆ ಹಾಗೆ ಇಟ್ಟಿದ್ವಿ, unless 2002 where we did once more. So 3 plus 1, the answer to the question is 4. Now for someone who has studied this, he would have directly answered it as 4. But for someone who did not come across this fact directly in test series or in the static part, then he could have done the smart guesswork by thinking in this sort of way. This is what I wanted to convey. So knowledge illa andru kuda how is that we can deduce? This is one of the ways. Few things about the delimitation commission. See, parliament through a delimitation act will constitute a delimitation commission for allocating the number of seats for each of the states and for redrawing of the boundaries of constituencies across the state. So in this delimitation commission, who will be heading it? Certain basic knowledge naಮಗೆ ಗೊತ್ತಿರಬೇಕು. It will be a judge of Supreme Court. Along with them, there will be election commissioner or concerned state election commissioners, and this group will constitute the delimitation commission. So like I said, 4 times ಆಗಿದೆ, 63, 73, 2002. ಅಲ್ಲಿ ಕೇಳಿದ್ರೆ 4 times. ಇದು ನೀವು 61 ಅಂತಂದ್ರೆ recall ಮಾಡ್ಕೊಳ್ಳಿ, 71 ಅಂತ ಮಾಡ್ಕೊಳ್ಳಿ. Exact years ನ ಏನು ಕೇಳಿಲ್ಲ, because this is not state PCS sort of thing. And the power of delimitation is been given under Article 82 and Article 170. 82 for Lok Sabha and Article 170 for state legislative assemblies. So delimitation commission will be appointed by the president, right? So it involves the fixing of number of seats like we discussed so on. So do not get confused. Delimitation, the work of delimitation will be done by a separate delimitation commission and not by the election commission of India. Usually ee tara statements ಕೊಡುತ್ತೆ, delimitation na ಕೊಟ್ಬಿಟ್ಟು election commission ಕೊಡ್ತಾರೆ. That is wrong. That is wrong when we speak of the mainstream India. Now I'll be telling you new things, new facts which we do not come across. What about the delimitation in the northeastern region? The delimitation in the northeastern region especially in the 4 inner line states Assam, Arunachal, Manipur and Nagaland. In these 4 states, which are the inner line permit ILP, inner line permit states. In these states, the delimitation will be done by the election commission and not by the delimitation commission. So idinne UPSC ಏನು ಮಾಡ್ತಾರೆ, delimitation commission does the task of delimitation commission across all the states of India and ಕೊಟ್ಬಿಡ್ತಾರೆ, but it is not in all the states. So here the president, and this power is not under a delimitation act, this power is under RPA Act of 1950. So under section 8A of RPA Act 1950, the president shall appoint a delimitation exercise to be done by the election commission for the following states. So Assam alli 2023 alli delimitation complete agide, but in the rest of the states the delimitation exercise is still to happen despite more than 50 years have passed since the last delimitation has taken place. 2008 alli delimitation ಮಾಡಬೇಕಂತಿದ್ರು, but there was a lot of protest and people objected to it because they felt that it did not reflect the demographic dynamics of the region. So these were the basic things which we need to know. Delimitation about the mainstream region we would have come across, but this was a new information, and UPSC will try to frame questions from things which you haven't come across. The Constitutional Amendment, 71st Amendment 1992 amends the 8th schedule to the Constitution to include which of the following languages? Konkani, Manipuri, Nepali, Maithili. See, 8th schedule alli there are 22 official languages. So which of the following are the official languages anta kelidre, Konkani correct, Manipuri correct, Nepali correct, Maithili correct. But il twist elide 71st amendment inda we know that when we study this in Lakshmikant, we know that there are around 3 to 4 times when the amendments had taken place and the languages were been added. But 71st amendment alli yaad add madidu exactly we do not know. For someone who knows, he would have directly answered that A is the answer. For someone who knows and who remembers, but when we study so many things we cannot remember this. So how is that we could have recalled? See, the way we study il matter agate. How is that we could have recalled? If you see, among the 22 official languages there are 4 tribal languages. Yadadu? Bodo, Dongri, Maithili and Santili. And if you see, all these 4 tribal languages were been added together by a certain amendment. Amendment number nanigu gottirlilla. Example, even I did not know which amendment that these 4 were added, but I knew that there were only 4 tribal languages and these tribal languages were added together. So club adre idu club agbeku. So Maithili needs to be club with these 3. So Maithili illa andre ee 3 illa, ee 3 illa andre Maithili illa. So see, Maithili jote these 3 and these 3 are different. So Maithili was not through 71st amendment. 4 eliminate madidra, answer A. Simple way of remembering, and this is what UPSC is also trying to test. It is not trying to test exactly if you are able to remember each and everything, but this is how you need to deduce. Ee tara now practice madidre, even when we are studying, if we see what are the patterns that we can see in whatever we study, this is how we could have got the question as correct. I did the same in the exam and got this correct, but many felt that this is a memory game and better be neglected. So once ati idr mel question bantu andre, it becomes important for the next year or the subsequent years. So 8th schedule, initially est language ittu, one basic idea irli. Now we have 22, but initially there were 14 languages. Sindhi was added by 21st amendment. Konkani, Maithili and Manipuri, Konkani, Manipuri and Nepali by 71st amendment. See, Bodo, Dogri, Santili, Maithili, they were added together. I did not know which amendment it was by 92nd amendment. But now a question has been asked upon this. We need to remember these 3 amendments: amendment 21st, amendment 71st and amendment 92. And here also we can see someone who is mad: 21st, 71st, 92, 71 ge 71 plus 21, 21 plus 71 ಮಾಡಿದ್ರೆ 92 ನೇ ಬರುತ್ತೆ. ಈ ತರನು ಜ್ಞಾಪಕ ಇಟ್ಕೊಬಹುದು. We'll move to the next question. Which of the following statements are correct about the Constitution of India? Power of municipalities are given under, see, this is a direct question which has been picked from the tabular column given in Lakshmikant. parts mele there is a separate tabular column. Part 1 deals with so and so union and states, part 2 so and so, part 3 so and so fundamental rights, part 4 DPSP, part 4A fundamental duties, part 5 union government, part 6 state government, part 7 division of power, part 8, part 9, part 8 and so on. Like this is what we need to remember. Parts ಮತ್ತೆ schedules by heart ಇರಬೇಕು, because mains ಅಲ್ಲಿ most of the times we'll be starting our question with so and so. Tribunals will banta. Tribunals are administrative bodies which are established for speedy redressal of the dispute, established under article 14A, established under part 4A and article 323A and B. ಈ ತರ ಡೈರೆಕ್ಟ್ ಆಗಿ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತೀವಿ. ಸೊ ನಮಗೆ ಪಾರ್ಟ್ಸ್ ಮತ್ತೆ ಸ್ಕೆಡ್ಯೂಲ್ಸ್ ಗೊತ್ತಿರಬೇಕು. And this needs to remember, we cannot be lazy and try to neglect it like many did and got this wrong. See, municipalities 9A, panchayats part 9, emergency provisions 18 and amendment of constitution 20th. All three statements are correct. There is nothing much to be discussed in this because this is directly picked from the static part. We'll move to next question. And also to remember the parts, just see on YouTube or Google if there is any mnemonic that could be made to remember. ಆ ತರ ಕೂಡ ಮಾಡಿ ಜ್ಞಾಪಕ ಇಟ್ಕೊಬಹುದು. Which one of the following statements is correct as per the Constitution of India? See, if you remember the previous 1 or 2 PYQs, ಅಲ್ಲಿ ಕೂಡ interstate ಅಂದ್ಬಿಟ್ಟು ಕ್ವಶನ್ ಬಂದಿತ್ತು, and there I said interstate ಅಂತ ಬಂದ್ರೆ the state government does not have the power, it is the parliament which will have the power. Now it is telling which of the following statements is correct as per Constitution of India. Interstate trade and commerce is a state subject. Interstate migration is a state subject. Interstate quarantine is a union subject. Corporation tax is a state subject. See, economics basics, corporation tax state subject alla. Interstate state subject, interstate union subject. PYQ discuss ಮಾಡಿ ಜ್ಞಾಪಕ ಇದ್ರು ಕೂಡ you could have got this wrong. PYQ ಡಿಸ್ಕಸ್ ಮಾಡಿಲ್ಲ ಅಥವಾ ಏನೂ ಗೊತ್ತಿಲ್ಲ, ಇನ್ ದಟ್ ಕೇಸ್ ಆಲ್ಸೋ ಈವನ್ ಇಫ್ ಯು ಲುಕ್ ಫಾರ್ ಪ್ಯಾಟರ್ನ್, ಇಲ್ಲಿ ಇಂಟರ್ಸ್ಟೇಟ್ ಇದ್ರೆ ಇಲ್ಲಿ ಸ್ಟೇಟ್ ಇದೆ, ಇಲ್ಲಿ ಇಂಟರ್ಸ್ಟೇಟ್ ಇದ್ರು ಇಲ್ಲಿ ಸ್ಟೇಟ್ ಇದೆ, ಅಂಡ್ ಆಪ್ಷನ್ಸ್ ಓನ್ಲಿ ಒನ್ ಆಫ್ ದಿಸ್ ಇಸ್ ಕರೆಕ್ಟ್. ಸೊ ಹೌ ಕ್ಯಾನ್ ಬೋತ್ ಬಿ ಕರೆಕ್ಟ್? ಇಲ್ಲೇನಾದ್ರು ಎ ಅಂಡ್ ಬಿ ಇದ್ರೆ ಕರೆಕ್ಟ್ ಆಗ್ತಿತ್ತು. ಸೊ ದಿಸ್ ಕೆನಾಟ್ ಬಿ ಕರೆಕ್ಟ್. ಸೊ ಇಟ್ ಡಸ್ ನಾಟ್ ಕಮ್ ಅಂಡರ್ ಸ್ಟೇಟ್ ಅಂತ ಕೂಡ ಈಸಿಲಿ ಅರ್ಥ ಮಾಡ್ಕೊಬಹುದು, ಈವನ್ ಇಫ್ ಯು ಡಿ ನಾಟ್ ನೋ ಎನಿಥಿಂಗ್. ಸೊ 7th schedule, article 246, division of power, interstate trade and commerce, interstate migration, corporation tax, all this will come under union subject. Moving to next question. Under which one of the following articles of the Constitution of India has the Supreme Court placed the right to privacy? Simple question, direct question. In last class also we discussed in detail about article 21 Puttaswamy judgment, where right to privacy was said to be an integral part of right to life and personal liberty. And right to life and personal liberty, article 21 bandaga, there is due process of law that is been followed, unlike procedure established by law. Due process of law, you know, and how is that been applied in Indian case, all this we discussed in the last class. What are the duties of the CDS as the head of Department of Military Affairs? See, CDS question, so many people had been waiting since its establishment that a question would appear. After 3 to 4 years it has appeared. So this is what happens. 2019 or something happens that will be asked in 2023. So a 4-5 years ಅಲ್ಲಿ ಏನೇನಾಗಿದೆ, most important things we need to be aware of. Not everything, but the most important things. CDS was one of those important things. So Chief of Defence Staff, Head of Department of Military Affairs. So what are his duties? Permanent Chairman of Chief of Staff Committee, okay. Exercise military command over the 3 service chiefs. Principal military advisor to Defence Minister of all tri-service matters. See, CDS ಬಗ್ಗೆ basic knowledge ಗೊತ್ತಿರಬೇಕು. Chief of Defence Staff. CDS was been established as the head of Department of Military Affairs. Now this Department of Military Affairs is under Defence Ministry. So Department of Military Affairs, the responsibility is to ensure coordination between the all 3 military arms, Army, Navy ಮತ್ತೆ Air Force. ಈ 3 personnel ಮಧ್ಯ there was less coordination earlier. So to bring about coordination, to undergo joint training of these 3 personnel, Department of Military Affairs was been established. So, and this has been headed by CDS. CDS is the chief military advisor or the principal military advisor when it comes to all tri-service matters. But there's also another important thing which we need to know, that his role is limited to the advising. He does not get a direct command. He does not get to directly command the 3 military chiefs. The 3 military chiefs are independent. The army chief will command the army, the navy chief will command the navy, and so on. The CDS does not get to command over the chiefs of these three arms. So 2 is wrong. Yenu gottilla andru saku, 2 wrong anta gottiru sakittu, answer banbidutittu. Right. So even if we did not know if it's the permanent chairman of chief of staff committee, even then we could have easily got the answer. And this is what actually happens. UPSC ella statement ge answer gotirbekanna necessity illa. Easily most irrelevant or most relevant option na now ellide anta now recognize madidru kuda we'll get the answer most of the times. And if you see 2024 paper, it is more of static thing compared to 2023. Most of the things memory oriented or bookish things in the it has been picked up. See, CDS, principal military authority, CDS, principal military authority, head of department of military affairs, principal military advisor, permanent chair of chief of staff committee, and CDS does not exercise direct military command over the 3 services. Move to next question. Which one of the following statements about the ethics committee in the Lok Sabha are correct? Initially, it was an ad hoc committee. Only a member of Lok Sabha can make a complaint relating to unethical conduct of a member of Lok Sabha. This committee cannot take up any matter which is sub judice. Ee statements ge yenenide, we'll try to recall whatever we learned from the PYQs. When we were talking about mandamus, we mentioned that mandamus is not applicable in certain cases. One of those cases was if a matter is sub judice. If a matter is before any court, then mandamus cannot be, we cannot get mandamus for that. So, if a matter is sub judice, then ethics committee, this is correct. If a matter is sub judice, then the ethics committee will not take up the matter. This is correct. See, ethics committee ಬಗ್ಗೆ ಲಕ್ಷ್ಮೀಕಾಂತಲ್ಲಿ basic things ಕೊಟ್ಟಿದ್ದಾರೆ. Ethics committee ಏನು ಮಾಡತ್ತಂತ ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದಾರೆ. If there is misconduct by any of the member of the Lok Sabha or Rajya Sabha, then the ethics committee will look into the ethicality of his action, his or her action. So initially it was a ad hoc committee, idu namage gotte illa, but only a member of Lok Sabha can make a complaint relating to unethical conduct of a member of Lok Sabha. Trap only. So only na wrong anta tagondre answer direct agi bartittu. Answer would be 1 and 3 even without knowing statement 1. So in this way also we could have deduced, and few other things which we need to know about ethics committee. See, ethics committee will oversee the moral and ethical conduct of its members, and ethical committee, ethics committee li Rajya Sabha kuda ide, Lok Sabha kuda ide. It isn't that only one house alli ide. Lok Sabha there are 15 members in the ethics committee, and in Rajya Sabha there are 10 members. Idin kelilla, so this is an extra information which is not mentioned in Lakshmikant. And how does this work? Also, the members of the ethics committee are appointed by the speaker or the chairperson depending on which house, and for a period of 1 year only. So how does this ethics committee work? See, if there is misconduct that has been conducted by a particular MP, then there is another MP who will see it, notice it, and he'll refer it to the speaker telling that this person has done misconduct. So the speaker will refer the matter to the ethics committee, and whatever ethics committee will find out, that will be given back to the speaker. Now speaker cannot directly take action based on the ethics committee recommendation. Even if ethics committee finds a particular person to be guilty, then the speaker will take up the motion and put it to the vote, and only if the motion is been voted, only then can some sort of punishment be given to the person who has done misconduct. So it is not the speaker who will be deciding the expulsion or the suspension of the member if it happens. It is the house. So ethics committee recommendation kottaga speaker will ask it to the house, and the house will take up a motion whether to suspend or expel the member, expulsion of the member, and based on that the person will be punished. ಸಿ ಎಥಿಕ್ಸ್ ಕಮಿಟಿ ತರಾನೇ ಪ್ರಿವಿಲೇಜ್ ಕಮಿಟಿ ಅಂತ ಕೂಡ ಇದೆ. ಒನ್ ಬೇಸಿಕ್ ಡಿಫರೆನ್ಸ್ ಇಸ್ ಇಫ್ ಇಟ್ is more serious acquisitions, then it will go to privilege committee. If it's less, then ethics committee. See, basic things we need to know. So what did we discuss? Who was the provisional president of the Constituent Assembly before Dr. Rajendra Prasad took place? See, ಹೇಳದ್ನಲ್ಲ, memory sort of things are asked more in 2024 paper. ಆದರೆ ಇವೆಲ್ಲ ಬೇಸಿಕ್ ಥಿಂಗ್ಸ್ ಇದನ್ನ ಗೊತ್ತಿಲ್ಲ ಅಂತ ವಿ ಕ್ಯಾನಾಟ್ ಟೆಲ್. ಡಾಕ್ಟರ್ ಸಚಿದಾನಂದ ಸಿನ್ಹಾ, ಲಕ್ಷ್ಮೀಕಾಂತ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಆಗಿದೆ, ಸ್ಪೆಕ್ಟ್ರಮ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಆಗಿದೆ, ನಿಮ್ಮ ಕ್ಲಾಸ್ ನೋಟ್ಸ್ ಅಲ್ಲ, ಐ ಹೋಪ್ ಇಟ್ಸ್ ಬಿನ್ ಮೆನ್ಷನ್. ಸಿ ಪ್ರೊವಿಷನಲ್ ಪ್ರೆಸಿಡೆಂಟ್ ಆಫ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಂಟ್ ಅಸೆಂಬ್ಲಿ ನಮ್ಗೆ ಏನು ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೂ ಕೂಡ provisional president of Constituent Assembly, it was not at all Ambedkar, at least this much we knew. C. Rajagopalachari, even this person was not the thing. And if we see in this person, among these two, if we had to choose, at least we would have done 50-50, even if we did not know anything. And among these two, if you see, there is more chances that you would have come across this name rather than this name. ಆ ಥರ ಕೂಡ ಥಿಂಕ್ ಮಾಡ್ಬೋದಿತ್ತು. Sachidanand Sinha was been appointed because he was the oldest member, and it was a French practice that we elect the oldest member as the provisional or the temporary president. And later Dr. Rajendra Prasad was been elected as the president of assembly, and there was H.C. Mukherjee. Who was appointed as the vice president. We'll move to next question. As per Article 368 of the Constitution of the Parliament, the Parliament may amend any provisions of the Constitution by way of 368. By using 368, Constitution can be amended by the Parliament through which of the following ways? It can add, it can vary, it can repeal. Simple question. ಇದರಲ್ಲಿ ಏನು ಡಿಫರೆನ್ಸ್ ಇಲ್ಲ, ಏನು ಥಿಂಕ್ ಮಾಡೋ ಅಂತ ವಿಷಯ ಇಲ್ಲ. ಆ್ಯಂಡ್ 368 ಬಗ್ಗೆ ಕೂಡ ಹೇಳಿದ್ದೀನಿ. ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ನ ಅಮೆಂಡ್ ಮಾಡಬೇಕಂದ್ರೆ ಸಿಂಪಲ್ ಮೆಜಾರಿಟಿಯಿಂದ ಮಾಡ್ಬೋದು, ಸ್ಪೆಷಲ್ ಮೆಜಾರಿಟಿಯಿಂದ ಮಾಡ್ಬೋದು. Article 368 deals with two types of majorities. One is special majority and another one is special majority plus the state governments. Half of the 50% of the state governments will have to agree for it. We already discussed about it. So it can make additions to the provisions of the Constitution, it can make deletion, or it can make changes. And we have seen all of this. For example, now emergency, when it was declared, they wanted to add more grounds to safeguard it. So 42nd amendment alli certain provisions, 44th amendment alli certain provisions were added to safeguard it, such as national emergency can be restricted to only a certain part of India. That was added. See, variation, repeal, if there is any, for example, now 39th constitutional amendment, it said the election of PM cannot be challenged at all. So such provisions were there which were repealed by 42nd amendment. So likewise, similar thing will happen to vary when a little changes is to be made. For example, vary first there was reservation for Anglo-Indians in Lok Sabha and state legislative assemblies, which was been removed by a amendment. I think it was 104th amendment which removed the reservation that was meant for Anglo-Indians in state legislative assemblies and in Lok Sabha. Same thing, and this power has been given by Article 368. We cannot forget this article. Next question, which one of the following statements are correct in respect of money bill? In previous year paper also we discussed, question on money bill has already appeared. So Article 109 mentions special procedure in respect of money bill. Okay, money bill shall not be introduced in Council of States, means Rajya Sabha. It's correct, basic thing. Rajya Sabha can either approve the bill or suggest changes, but it cannot reject it. This is also correct. Amendments to a money bill suggested by Rajya Sabha have to be accepted by Lok Sabha. This is wrong. See, ಇನ್ನೊಂದು ಏನು ಗೊತ್ತಾ, ನಾನು ಆಲ್ರೆಡಿ ಹೇಳಿದ್ದೀನಿ, UPSC sometimes to make things easy, it will give contradictory statements. Contradictory statements ಅಂದ್ರೆ 3 itself is opposing 4, 4 itself is opposing 3. So 3 and 4 can never be together because one of them is wrong. So 3 correct anta gottide because it is a basic thing. 3 correct. That means 2 is also correct. We know 2, 3 are correct. So whether 1 is correct. Confusion ಏನೇ ಇದ್ರು ಈ ವರ್ಡ್ ಆಪ್ಷನ್ ಮಧ್ಯ ಮಾತ್ರ ಇರಬೇಕು. And this happened in exam also. And if we think of money bill, Article 109 mentions special procedure with respect to money bill. The only confusion should here be is whether it is Article 109 or not. Special procedure, definitely the money bill. The money bill is introduced with the previous consent of the president. The money bill is introduced only in the Lok Sabha and not in the Rajya Sabha. The money bill, when it is given to the assent, then the president has to give the assent or reject it. He cannot return it. So these things are there. And the Rajya Sabha, when it comes to money bill, it can only suggest the provisions or accept. It cannot reject the bill. So these are the special procedure dealing with the money bill. We know that there is a special procedure, but whether it comes under Article 109 or not, is a confusion irbekitu. It actually comes under 109. This was one of the confusion which aspirants had when actually they were attempting the paper. So 109 under ittu, we come across 110, article number 110. We come across article number 112, but 109 no namige gottirbeku. That is what UPSC wanted to test. Another question. See, even this question has been picked up from Lakshmikant, but it is picking up those information which is not mentioned in Lakshmikant. Just like there we saw of ethics committee, similar thing here. Northeastern Council. We know Northeastern Council similar to zonal councils. Northeastern Council has been established, but zonal council State Reorganization Act under established madidro. Northeastern Council established under Northeastern Council Act 1971. So the council will comprise of which of the following members? Governor, Chief Minister, 3 members as nominated by the President, and Home Minister of India. This was another controversial question which UPSC gave. Why? Because see, idralli yes work madodu kuda kashta ide because the solution is controversial. I'll tell you why. When it came to Northeastern Council, I knew only one thing, a couple of things. What was the objective of NEC? Which we get to know that the development of Northeastern region. And I knew that it was the Home Minister who was the president of it, and Minister of Development of Northeastern region. Minister of Development of Northeastern region. Minister of Development of Northeastern region. He was the Vice President. Istu gottittu. So with this in mind, I kept Home Minister to be correct. So I was trying to see which of these 3 are correct. But I did not know about the other members. But the actual answer is exactly reverse. It's A. Because Governor is a member of the council, CM is also a member of the council, and the 3 members will have to be nominated by the president, and these 3 are the members. Home Minister is the chairman, and they have not considered him to be member in this question. He is the president. He is the ex officio president. Even if you Google this, you will find this information. So this was another controversial question. UPSC took out the answer to be 1, 2, 3 and not 1, 2, 3, 4. So this is where sometimes we deviate. Naven ankonti vadalagala UPSC in answer tegite, that will be the final. So this was one of those controversial questions. Like I said, ex officio chairman, Union Home Minister, Vice Chairman, Ministry of Development of Northeastern region. If you see the solutions of various institutes, they would have addressed only first three statements. They didn't speak about this thing. Whereas before the exam, whichever institute page that you opened, they themselves used to mention this thing. So this is what aspirants knew, but I'll bear the name. And basic things we need to know. Northeastern region, it is a statutory body because, like I said, established under Northeastern Council Act of 1971. So it will include all the 8 states of the Northeastern region. So council al yaru irtare gothirbe, governor, CM and 3 members who will be nominated by the president. We'll move to next question. Another important question, a current affairs question you can say. Nari Shakti Vandan Adhiniyam, which is nothing but providing reservation for women in state legislative assemblies and in Lok Sabha. A much awaited reform that was needed since a very, very long time. So it was done through 106 constitutional amendment. Now how much reservation do we give? 1/3 reservation needs to be given for women in Lok Sabha and state legislative assemblies, not in Rajya Sabha or state legislative councils. So provision will come into effect from 18th Lok Sabha. See, it will come into effect. You take 10 to 15 years PYQs and you see it will come into effect. Itara LNU statement nodidre mostly it wrong irutte. It will come into effect. They will tell a scheme. they will tell that it will be enforced from so and so. If future tense ಇರೋದು will be wrong, because ಫ್ಯೂಚರ್ ಏನಾಯ್ತು ಎಕ್ಸಾಕ್ಟ್ಲಿ ಅವರಿಗೆ ಗೊತ್ತಿರಲ್ಲ. ಸೊ ಈ ತರ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಅವ್ರು ಕೊಡಕ್ ಹೋಗಲ್ಲ. ಅದು ರಾಂಗ್ ಅಂತ ಗೊತ್ತಿದ್ರೆ ಮಾತ್ರ ಕೊಡಕ್ ಹೋಗ್ತಾರೆ. ಸೊ ಪ್ರಾವಿಷನ್ಸ್ ವಿಲ್ ಕಮ್ ಇನ್ ಟು ಎಫೆಕ್ಟ್ ಫ್ರಮ್ 18th Lok Sabha. 18th Lok Sabha has already started 2024. ಸೊ ಇಟ್ ಇಸ್ ನಾಟ್ ಇನ್ ದ 18th Lok Sabha. ಒಂದು ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಆನ್ಸರ್ ಬಂದ್ಬಿಡ್ತಿತ್ತು. ಏನು ಗೊತ್ತಿಲ್ಲದೆ ಕೂಡ without knowing anything about this scheme, even then we would have got the answer. This will be in force for 15 years after becoming an act. This is correct. There are provisions for reservation of seats for SC women within the quota reserved for SC. ಯಾವುದೇ ಸ್ಕೀಮ್ ತಗೊಳ್ಳಿ, ರಿಸರ್ವೇಷನ್ ತಗೊಂಬನ್ನಿ, ಆ ರಿಸರ್ವೇಷನ್ ಮತ್ತೆ ಸಬ್ ರಿಸರ್ವೇಷನ್ ಆಗುತ್ತೆ. ಸೊ ಈ 1/3 ವುಮನ್ ಅಲ್ಲಿ ಮತ್ತೆ 1/3 ವುಮನ್ ಅಮಂಗ್ ಅಲ್ಲಿ ಕೂಡ 1/3 SC ವುಮನ್ ಸೀಟ್ಸ್ ರಿಸರ್ವ್ ಆಗಿರುತ್ತೆ. ದಿಸ್ ಇಸ್ ಅ ವೆರಿ ಕಾಮನ್ ಥಿಂಗ್. ದೇರ್ ಇಸ್ ನಥಿಂಗ್ ನ್ಯೂ ಆರ್ ನಥಿಂಗ್ ಸ್ಪೆಷಲ್ ಅಬೌಟ್ ಇಟ್. But we need to know the basic 106th constitutional amendment, and this reservation shall be applicable only to Lok Sabha and Assembly of the state, and for the legislative assemblies of National Capital Territory of Delhi. So Delhi ಗೆ ಮಾತ್ರ applicable ಆಗುತ್ತೆ, ಬೇರೆ ಯಾವ ಯೂನಿಯನ್ ಟೆರಿಟರಿಗೂ applicable ಆಗಲ್ಲ. So similar thing SC ST ಗೆ ಮತ್ತೆ ಅದರ ಸಬ್ ರಿಸರ್ವೇಷನ್ ಬರುತ್ತೆ, and it shall come into effect, it shall be in effect only for a period of 15 years. So that is why it has been criticized as a token representation. It will come into effect, and when will it start? So it will start once the first delimitation exercise will be taken place. So once this is done, after that whatever comes, so commonly it has been expected that such reservation will begin from 19th Lok Sabha, which will be from 2029. ಇವಾಗಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗ್ಬೋದು ಅಂತ ಒಂದು ಎಸ್ಟಿಮೇಷನ್ ಇದೆ. Next question, a writ of prohibition is an order issued by Supreme Court or High Court. See, this also we spoke. How do you remember the five writs? Har, Maggie, Page, Chicken Qureshi. Last class we already spoke of this. You can watch it if you want. A writ of prohibition is an order issued by Supreme Court or High Court. So higher court will issue the writ of prohibition to a lower court when it is exceeding its authority. To a government officer, to a parliamentarian, to a lower court. Simple question, direct answer. ಮತ್ತೆ ಇದರಲ್ಲಿ ಇನ್ನೊಂದು ಏನಂದ್ರೆ, writ of prohibition can be issued against whom, it cannot be issued against whom ಗೊತ್ತಿರಬೇಕು. Only if it is of judicial or quasi judicial authority, only then it could be issued against them. It cannot be issued against administrative authority. It cannot be issued against the High Court or Supreme Court judge, or against President, Governor, or even a private organization or a individual. Istu ಗೊತ್ತಿರಬೇಕು. Not available against administrative authorities, legislative bodies, or private individuals or bodies. Look at the next question. Consider the following statements. It is the governor of the state who recognizes and declares any community of the state as scheduled tribe. See, same question. If you see 2 years ಮುಂಚೆ PYQ, same thing it has been mentioned. ಅಲ್ಲಿ ಪ್ರೆಸಿಡೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, and we said that it is correct, and it ಅಲ್ಲಿ ಏನಂದಿದ್ದಾರೆ, SC ಹೆಸರು ಹೇಳಿದ್ದಾರೆ. ಸಿಮಿಲರ್ ಥಿಂಗ್ ಇಲ್ಲಿ ST ಅಂದಿದ್ದಾರೆ. ಸೊ ಶೆಡ್ಯೂಲ್ ಟ್ರೈಬ್ ನ ಯಾರು ರೆಕಗ್ನೈಸ್ ಮಾಡಿ ಡಿಕ್ಲೇರ್ ಮಾಡ್ತಾರೆ, ಇಟ್ ಇಸ್ ದ ಪ್ರೆಸಿಡೆಂಟ್ ಅಂಡ್ ನಾಟ್ ದ ಗವರ್ನರ್. ಕನ್ಫ್ಯೂಸ್ ಆಗಬಾರದು. A community declared as scheduled tribe in a state need not be so in another state. This is a very commonsensical thing. There are so many OBCs who are OBC in certain state, not OBC in another state. There are SCs in certain state, but they do not claim SC status in another state. This is simple thing which we need to know. Under Article 342 itself, it has said that President may, with respect to any state or union territory, shall, in consultation with the governor, declare a particular tribe to be scheduled tribe, and that shall happen through a public notification. So President will have the right to include or exclude this from the list of scheduled tribes, and the President shall not do it on the basis of the discretion. He will be doing it on the aid and advice of the Council of Ministers. President ಏನೇ ಮಾಡಿದ್ರು aid and advice of Council of Ministers, except that 4-5 things where he has discretionary power. With reference to union budget, consider the following statements. Union Finance Minister, on behalf of Prime Minister, lays the annual financial statement. Annual financial statement, Article 112. Before both houses of the Parliament, at the union level, no demand for grant can be made except on the recommendation of President of India. Simple question, simple statement, correct. Union Finance Minister on the behalf of Prime Minister. See, Union Finance Minister shall lay the budget on behalf of the President and not the Prime Minister. ಇನ್ನೊಂದು ಇಶ್ಯೂ ಇಲ್ಲಿ ಏನಂದ್ರೆ UPSC ಮತ್ತೆ ಕಾಂಟ್ರವರ್ಷಿಯಲ್ ಕೀ ತಗೊಂಡಿದೆ. This is supposed to be wrong, but UPSC has taken this as correct. So answer was supposed to be B, but the answer is C in the UPSC official key. This is where the accountability is been lacking when it comes to UPSC, because it will take out these sort of keys and there is hardly any challenge that is been done. ಈಗ ಹೋಗ್ತಾ ಹೋಗ್ತಾ ಇನ್ನೂ ಕಾಂಟ್ರವರ್ಷಿಯಲ್ ಆಗ್ತಿದೆ. So this is Union Finance Minister on behalf of the President. So ಈ ತರ ಕಾಂಟ್ರವರ್ಷಿಯಲ್ ಕೀ ತೆಗೆದಾಗ these sort of things will never be repeated again in any of the papers. ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ನ ಮತ್ತೆ ತಗೊಂಡು in next 10 years ನೀವು ನೋಡಿದ್ರು ಕೂಡ they will not take it out, this statement in the question. ಈ ತರ ಸ್ಟೇಟ್ಮೆಂಟ್ ನ ಕ್ವಶನ್ ಕೊಡಕ್ಕೆ ಹೋಗಲ್ಲ, because they know that they have made a mistake. So next time ಅದನ್ನ ಕರೆಕ್ಟ್ ಮಾಡಕ್ಕೆ Union Finance Minister on behalf of President ಅಂತ ಕೊಟ್ಟು ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಮಾಡಿದ್ರೆ then ಇಲ್ಲಿ ರಾಂಗ್ ಅಂತ ಅವರೇ accept ಮಾಡ್ಕೊಬೇಕಾದ್ರೆ. So they will not at all ask. So 113, no demand for grant can be presented in Lok Sabha without the President. And Article 112 ಕೂಡ ಹೇಳಿದೆ, President of India shall cause to be laid before both the houses the annual financial statement. So it is on behalf of the President and not the Prime Minister. We'll move to next question. With reference to Speaker of Lok Sabha, which of the following statements are correct? While any resolution for the removal of Speaker of Lok Sabha is under consideration, then which of the following statements given above are correct? He or she shall not preside. Simple thing, correct. He or she shall not have the right to speak. Okay. He or she shall not be entitled to vote on the resolution in the first instance. Both this and this are wrong. Answer is A. Why? Because when a resolution is been adopted to remove the speaker, then that resolution will, one thing, it needs effective majority. Speaker na remove ಮಾಡಬೇಕಂದ್ರೆ effective majority ಬೇಕು. Special majority, effective majority, whatever you call, ಅದು exactly ಏನಂತ ಗೊತ್ತಿರ ಆಯ್ತು. Special majority means the people who are voting, it should actually constitute more than 50% of members present and voting and more than 50% of the total strength of the house. So Lok Sabha League 545 members idre 270 plus 273 274 members vote ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಸ್ಪೀಕರ್ ನ ರಿಮೂವ್ ಮಾಡಬಹುದು. And when a resolution for the removal of speaker is in place, the speaker shall have the right to speak, but the speaker shall not be heading the house. So that is why the speaker shall not be presiding, but the person will have the right to speak. Sumne made up statement idu wrong ಮಾಡಕ್ಕೆ. And he or she shall not be entitled to vote in the second instance. Usually ಏನಾಗ್ತಿತ್ತು, when a MP is acting as a speaker, then he is supposed to be neutral. So house ಅಲ್ಲಿ in case both the sides of the resolution, for and against, ಎರಡು side of the resolution ಅಲ್ಲಿ 50-50% ಆಗಿದೆ, then in the second instance speaker would have exercised a casting vote. But when a resolution for his removal is in place, then speaker is treated as a normal MP of the house. So in that case he is allowed to vote only in the first instance but not in the second instance. So this is wrong. ಇಲ್ಲಿ ಫಸ್ಟ್ ಇನ್ಸ್ಟೆನ್ಸ್ ಅಲ್ಲೇ ಬಿಡಲ್ಲ ಅಂದಿದೆ, ಸೆಕೆಂಡ್ ಅಲ್ಲಿ ಬಿಡಲ್ಲ, ಫಸ್ಟ್ ಅಲ್ಲಿ ಬಿಡ್ತಾರೆ. Whereas similarly vice president or the chairman of Rajya Sabha, see, chairman of Rajya Sabha or the vice president, he is not a member of the house. So if a resolution is being adopted for the removal of vice president or the chairman of Rajya Sabha, then he cannot vote in the second instance nor can he vote in the first instance, because first instance ಅಲ್ಲಿ vote ಮಾಡಬೇಕಂದ್ರೆ you should be member of the house, but he is not a member of the house, so he cannot vote. Okay. With reference to Indian Parliament, consider the following statements. A bill pending in the Lok Sabha lapses. See, idu ಗೊತ್ತಿರಬೇಕು. Usually Lok Sabha is subjected to dissolution, Rajya Sabha is not subjected to dissolution, and when Lok Sabha is been dissolved, all the notices, memos, whatever things are there, it will be dissolved. But there are certain bills which will be dissolved, but certain bills that will not be dissolved. ಅದರ ಮೇಲೆ ಕ್ವಶನ್ ಫಾರ್ಮುಲೇಟ್ ಮಾಡಿದ್ದಾರೆ. A bill pending in Lok Sabha lapses on its dissolution, it is correct. A bill passed by Lok Sabha and pending in Rajya Sabha lapses on the dissolution, this is also correct. A bill in regard to which the President of India notified his or her intention to summon the houses to a joint sitting lapses on dissolution, it does not lapse. 3 is wrong, 1 and 2 are correct. So how do you remember this? usually the trick is when does it lapse? Or when does it not lapse? Either way gnapka. See, whenever Lok Sabha is been involved, it will lapse. Idane expand ಮಾಡಿ ಹೇಳಬೇಕಂದ್ರೆ, if a bill originated in Lok Sabha and passed to Rajya Sabha, it will lapse. If a bill originated in Rajya Sabha and passed to Lok Sabha for its decision, then it will lapse. Wherever this Lok Sabha will come, it will lapse. When does it not lapse? If a bill originated in Rajya Sabha but it is not yet passed to the Lok Sabha, then it will not lapse. If both houses have passed and it is supposed to get the president's assent, then it will not lapse. If there is disagreement between the houses and president has summoned for a joint sitting, then it does not lapse. Ivella gottirate. One more thing which I want to tell is when does not lapse? If the bills are pending, if the pending assurances are to be examined by the Committee on Government Assurances. Parliamentary committees ali we have this Committee on Government Assurances. So whatever assurance has been made in the bill by any MPs, then that will be examined by Committee on Government Assurances. So that bill will not be lapsing even if Lok Sabha dissolves. This was extra information which I wanted you to note. President reconsideration, joint sitting, pending assent, in all these cases the bill will not lapse. Okay, we'll come back to the question once again. Like I said, prorogation of the House by the President does not require the advice of Council of Ministers. It requires, one is wrong. Just check what it is actually meaning. See, prorogation, there is no bar for the President in prorogating the House, which is in session 2 is also correct. So in this, on the basis of this, we get C as the answer. See, illi tumba husharagirbeko because this is sort of new term. Dissolution of Lok Sabha is done by the President, who, remove this, who in exceptional circumstances does so on the advice of Council of Ministers. There is a provision that the Prime Minister along with the Council of Ministers, they can call for the dissolution of the House when the House does not represent the interest that is needed for the functioning. So in such case, not just no confidence motion through kuda Lok Sabha na dissolve ಮಾಡಬಹುದು, but the Prime Minister headed by Council of Ministers can also ask the President to bring about the dissolution of the House when they feel that the House is not representing the interest that is needed. So this is also one of the provisions. So in general case, dissolution of Lok Sabha can be done by the President on a discretionary basis, but under exceptional circumstances, he can also do it on the advice of Council of Ministers. 2 and 3 are correct. See, ade nodi, statement 1 ಮತ್ತೆ 3 ಎರಡು wrong ತರ ಇತ್ತು. I was looking for option 2, but option 2 is not present. But in such cases, what is that we need to do? First, pick the most wrong which you are sure about. So prorogation ge does not require the advice, pakka wrong anta gotu because advice is needed. So 1 becomes wrong. So in that case 3 na automatically correct anta ತಗೊಬೇಕು, and we know 2 is correct. So ಆ ತರ ಆನ್ಸರ್ ಮಾಡಬೇಕಾಗುತ್ತೆ. This will happen even in the upcoming exams also. So under Article 85 subclause 2, President from time to time will call about prorogation of the houses, and it will require the advice of Council of Ministers, and President may on his discretion can look for alternative government, which we already spoke about. So I think this was it. So this was all about 2024 Polity Prelims PYQ. I hope you liked the video. Thank you for watching.